Yes. Yes. Last time we covered section 33, 34, 35, relevancy of statement made in the map chart, isn't it? That is statements made under special circumstances, which we're dealing 34, 35. 35 clean ho gaya na, isn't it? 35. What section now? Anybody can remind
Sir,
me?
we had to start new section. We had completed. I will just let you know in a second.
Please note.
So we have to deal with section 39 on 39.
So 38, we have covered 38. Okay. 39, that is how much of a statement is to be proved. 39, how much of a statement is to be proved? Yeah. Yes. When evidence to be given, when statement form part of a conversation, document, electronic record, books, series of letters and part. So a letter may be containing 110 pages. Conversation may be containing for half an hour to 1 hour. An electronic record, your messages, email messages may be lengthy. When the entire document, series of documents are produced before the court of law, only the relevant portion which is connected to the charge or a fact in issue need to be proved here. How much? Yeah. When any statement of which evidence is given forms part of a longer statement or of a conversation or a part of a isolated document or is contained in document which forms part of a book or is contained in a part of electronic record or connected series of letters or papers, evidence shall be given of so much and no more of the statement, conversation, document, electronic record, books, series of letters, as the court consider necessary in particular case to the full understanding of the nature and the effect of the statement and the circumstances under which it was made. See, it's a very lengthy document you have learned under the Evidence Act. Falses in, falses in omnibus. A witness may make lengthy statement. Huh? It doesn't mean false in one thing he has stated, mean false in everything. Nahi. A statement which is believable, which is good enough, can be considered by the court. It's like Evidence Act, removal of a chaff from the grain. Sometimes the duty of a judge. So 10 paragraph of a statement containing of a person, only 2 pages are relevant. See, the judge has to cull out. You have to point out to the learned judge, the trial judge, at the time when you're leading evidence in examination chief or in the cross-examination, re-examination. Only this portion of the evidence is relevant for the purpose of this particular charge, and the remaining portion is irrelevant. Then conversation is recorded in a tape recorded statement of a person with regard to veracity, non-veracity. In R.M. Malkani's case and various cases, the Supreme Court said that the statement which is recorded in a tape record, which may be a illegally recorded statement, if it is relevant, it is admissible to what extent? If it is relevant to the charge which is framed against the accused person, and not the conversation which is not connected to the issue in the matter. So that is how the job of a good cross examiner or the evidence, the lawyer who is leading examination chief before the court, it is an art to point out, pinpoint to the court, but only certain paragraphs are relevant, which are series of the transaction and not the entire thing. So fortunately in India, the doctrine of falses in, falsus in omnibus is not applicable. In England, agar aapka evidence in one paragraph is wrong, the entire evidence is thrown out. But India ke andar ye concept nahi hai. So if it is a statement of a person is good enough in 2 paragraphs, that good part of the statement is considered by the court, and the remaining portion which is not relevant, which is falsehood, is removed from the court. That is removal of a chaff from the grain. So this is what the purpose sought to be achieved by the section 39. So the principle here is the real meaning of the sentence and passage can be understood by reading of the whole of the literature on which a sentence or a passage forms the part of it. So we must read the whole, not because they desire the remainder of this own stake, but because without that we cannot be sure we have the true. So in a particular novel or a book, you may say that the author has written certain defamatory comments against the plaintiff or applicant. So you are culling out the defamatory portion of a book which is 1,000 pages. All 1,000 pages are not defamatory, but it becomes relevant. But when you are deciding when a particular film is a category or U category, whether the certificate has been correctly given, not given, the court has to see the entire film. Uh, the entire film. Many matters are going to the court of law almost every day. This particular film is defaming us, and this particular film is not good for us and my ancestors, and we have been defamed. Various things are there for proving defamation, for proving statement which are adversarial to you, not in good taste to your family, which are considered defamatory, which are considered offensive. Then you have to read the entire novel. You have to see the entire movie picture. You cannot tell. The Supreme Court is now watching the entire movie. Recently, the Bombay High Court watched the entire movie to find out what is wrong in it. The division bench of the Chief Justice recently dismissed this petition which has been filed. Don't screen the film because the court said you are not challenged the certificate. Without challenging certificate, you cannot tell that here this is something defamatory. Rightly, it was in Bandit Queen also. You know that here the real life of that woman was depicted. And many people said that here our community clan is sought to be defamed, Bandit Queen. But a beautiful judgment of Justice Barucha, which is said that your right under Article 19(1)(a) cannot be curtailed. It's a freedom to mention your free. That is curtailed. You cannot see somebody is offensive when you are projecting a particular film, writing a particular novel. In what context is written? So it is a duty of the court to call out. Yeah. Oh, yeah. So the entire statement should be read over. So then it is all time dangerous that to admit a portion only on a conversation, so and so. Yeah. So from the reading of section 39, laid down that the statement to be proved is a part of a longer statement or conversation contained in a book or a part of a series of letters. I'm giving a letter. The evidence shall be given so much of the statement, conversation, document, book are contained in the form of electronic record or yeah or yeah the series of letters or papers as the court considers in a particular case necessary or connected to full understanding of the nature and the effect of the statement and the circumstances to which it was made. But that particular part which is not helpful in understanding the meaning of relevant statement shall not be proved. So you are not under obligation to prove each and every point. You are enjoined with a duty to connect the particular statement to the fact in issue before the court. How the fact in issue or a charge which is criminal court is trying a particular charge, a defamation charge, maybe sedition charges, that you have to read it out. This particular, now the government of India has invoked the Unlawful Activities Act against a particular accused. The sedition charges have been invoked. This is a highly defamatory and this statement is against national interest. In a series of books and articles written, to relevant portion only need to be brought to the attention of the court by virtue of this section. Then what is rendered admissible under the section is what the court find necessary in order that the statement may be intelligible. But it cannot be said that because the document is inadmissible. For certain purpose, all recital statement reference therein can be used as part of the fact which the court can deny. It must be remembered that an evidence which has been debarred by some sections of Evidence Act cannot be brought on record under Section 39. certain sections of the Evidence Act tell you it is an embargo. You cannot bring it. Like, for example, Section 41 tells you, certain proceedings only are conclusive. Insolvency proceedings and testamentary proceedings and admiralty proceedings. These are the proceedings which are conclusive evidence. And you cannot bring each and every judgment, which is judgment in a personam, because judgment in rem, which is against the entire world, is barred and can be used under Section 41, which are conclusive evidence. You need not lead evidence in rebuttal. But you cannot say that the court has passed an order of eviction, the court has granted an order of injunction, the court has granted an easementary right. Those judgments cannot be brought within the purview. There is a what you call it, implied estoppel. There is a provision in the court, like the provisions of Section 33 of the Evidence Act. You can use Why is it saying hold on? Are you able to hear me? You are able to hear me? Hello?
Yes, sir. Yes, sir. You are audible,
So,
loud and clear.
so one of the embargo I'm using, for example, we learned yesterday, Section 33. Section 33 के हिसाब से, the previous statements or evidence of a party in earlier proceeding can be used in subsequent proceeding, provided he was cross-examined. That is the condition. But now take, for example, under the CRPC, you learn under the scheme of Section 273 CRPC tells you evidence must be recorded in the presence of the accused, that the magistrate is enjoined with a duty to record evidence in the presence of the accused. So suppose if the accused is absconding, like for example, Dawood Ibrahim is absconding, he is in Pakistan or in Dubai, whichever foreign country, but the many cases have been tried against him. There are many witnesses against him. Can the evidence in the previous proceeding not used against him? Yes, certainly. That Section 273 is not a bar, because under Section 299 CRPC, when you open that, the court has power to record evidence against the accused in the absence of the accused, where the accused has deliberately remained absent, where the proceedings under Section 80 CRPC were invoked against him. For example, just open your CRPC, I will tell you, giving you illustration. Section 273 खोल लीजिए आप, to understand this concept here. Section 273, yeah, that is a evidence in inquiries and trial. Section 273, evidence to be taken in the presence of the accused. This is a mandatory condition, but there's a proviso says that here, women below the age of 18 years in rape cases, she need not be confronted by the accused, but a fair opportunity to be given cross-examination. Now, the relevant section I am pointing out, Section 299. 299 check करें आप. Record of evidence in the absence of the accused. Now, this is a departure from Section 273. So when you are going to practice criminal law, you should be able to know this and lay your hand. Now see that if it is proved that an accused person has absconded, mean he is not available for service, summons cannot be effected, warrant have been issued, and he is not answering. Like for example, the bomb blast accused, many of them have absconded, that there is no immediate prospect of arresting him. The court competent to try or commit for trial such person for the offences complained may, in his absence, examine the witness, if any, produce on behalf of the prosecution on such person. Like, for example, the trial of the Pakistani gentleman who was sentenced to death punishment, Ajmal Kasab's case, for example. Almost all the prosecution witnesses were ex parte because they were not available, they were not coming forward. Now then, be given in evidence against him on the inquiry into trial of the offense with which he is charged, if the deponent is dead or incapable of giving evidence. So those witnesses who were examined in that case, Ajmal Kasab's case, or any of the bomb blast cases, because there was no opportunity to cross-examine. If they were dead, incapable of giving evidence, cannot be found, or his presence cannot be procured without any amount of delay, expenses, inconvenient, under the second case would be unreasonable. Then subsection 2. So this is a departure. This is a departure from the general rule under section 273. So even the provisions of section 33 of the Evidence Act, which normally says that evidence which is recorded ex parte without cross-examination cannot be used, but for the purpose of 299 it can be used. You have to tell the magistrate or the court, here in the present matter, the accused, the witnesses who are sought to be examined, whose previous deposition I am relying upon. Number one, in that the court recorded the evidence in the absence of the accused. The accused was given sufficient opportunities, but the accused was absconding. When the accused was absconding, you know that the courts invoke the provisions of section 80, proclamation of the person absconding. Section 82 was invoked. A proclamation newspaper में आएगा सबके अंदर. His property was attached under section 83 CRPC and he was not available. But the court recorded the evidence under 299. So this evidence can be used for the purposes of other proceedings. Okay, this is an embargo which you should be able to remember it. Please note that. Okay, this is one example here. Yeah, anybody has any problem, anything to ask me? Please go ahead before I take the section 40.
So one question, sir, on section 299 CR.
Yes.
So yeah, the court can record the evidence of the witnesses for the prosecution. And if you could please clarify what happens if when finally the accused is arrested, whether he can, and the witnesses are untraceable or dead or cannot depose once again or be present for cross-examination, then what right would the accused have, sir?
Well, at what stage the accused is appearing? If the accused is dead and gone, that the evidence which is recorded under 299 would be binding upon him. The court can use against him. Or he may say that he must be in a position to bring better witnesses to dislodge them. That is called rebuttal evidence. That is the only opportunity he has got. He may prove that the evidence which has been recorded of a person who is dead and gone is not a reliable evidence. And the witnesses which I am going to examine, or my statement under 311 CRPC, which I am describing the circumstance of the case, they have more weightage. That is the only option. 311 is the option. That is under the provisions of 311. You learned it. 311. It is a 313. Power of the court to examine the accused, and accused person competent to examine witnesses under 315. So his witnesses must be superior witnesses, sterling witnesses whose evidence must outshine the evidence of the prosecution. Then it's a discretion of the judge. It's a matter of appreciation. The judge will weigh the evidence. Iska evidence is good, uska evidence is good. It's a discretion of the court to accept it. But the evidence which has been recorded of the dead witnesses can be used, but it can be shown that it is inferior evidence. It can be shown that the evidence which is recorded of the previous witnesses who are dead and gone, not available, is of not a good quality evidence. It's a inferior evidence, and it is not a. It is more of a hearsay evidence, and it is not a direct evidence. And he never had any opportunity. He did not see anything. But whereas I am examining new witnesses under 315, they are the persons who are direct witnesses. I have a circumstantial evidence which are linking the each chain. Then you have to show. Is that okay?
Yes, sir. Yes, sir. So I
That is the
understand that
only answer I can give you. Otherwise, you have no other choice. But the court will not set aside the evidence which has been recorded earlier. The court may disbelieve the witness. The court may say that here, though the accused had no opportunity to cross-examine them, but the evidence, the witnesses who examine are better quality witnesses. They are sterling witnesses. So I have no reason to disbelieve the witnesses examined by the accused person under 315. Yeah. So 299 ka effect hai ke, 299 will be available. But the moment the accused person reappears, 299 ke evidence and prosecution will be off colored. They will be of less significance. It's like setting aside the ex parte decree obtained under certain circumstances, like under Order 30, Order 9, Rule 13, you make an application setting aside. So you are setting aside, of course, the witness is dead and gone. There is no question of setting aside. It's a matter of appreciation of evidence. Yeah.
Sir, just one clarification. So under 299, when court requires evidence, the judgment can be drawn on that basis, right? Like
Yes.
you. Okay, sir.
There is no bar because the accused has not remained present. The accused is absconding. So 82, 83 proceedings CRPC के अंदर invoke किए उसके खिलाफ. Attachment of his property, proclamation, beating of the drum, सब announce हो गया. वो होने के बावजूद then only that means it's a very rare step the court takes. The court doesn't like to. You read the judgment of the Supreme Court in Ajmal Kasab's case, Nowtej Sidhu's case, where the witnesses did not remain present, the bomb blast cases and the parliament attack cases. ये सब cases में आपको मिलेंगे. Mostly evidence was recorded under 299. वे terrorist act करके भाग जाएंगे ना, थोड़ी they will face. Those who have been captured, yes. And many of them commit suicide also in the jail. And how many times Admal Kasab tried to commit suicide, but he was safeguarded. He was, kept under a very close vigil. Yes. Yeah. Anybody before let us now proceed to section 40. Is that clear? Judgments of the courts of justice when relevant. Relevancy of judgments of the court. So whether all judgments given by all court relevant, or the judgments are relevant to what extent and of which court? Court competent, not competent. So the only judgment which we have learned so far while discussing the conclusive proof, that is section 41 पढ़े हमने. So 40, 42, 43, 44 पढ़ेंगे आज. Till 44 तक जाएंगे, stop करेंगे. 45 opinion of the expert I will take it from tomorrow. So I will today deal with section 40, 41, 42, 43 and 44. Okay. This covers the relevancy of judgments of the court, to what extent the various judgments. So judgments are judgments in rem, judgment in personam. Mean judgment affecting the entire world, सारी दुनिया के लिए, and personam, the parties to the proceeding. So उसके बारे में सुनेंगे अभी. अब बताएंगे exactly how you can invoke a judgment given by a previous court is whether it is valid in a subsequent proceeding, res judicata under section 11 or 390, 300 CRPC. You cannot have double prosecution, isn't it? You cannot have it. It is whether the court has convicted you, prosecuted you, can you again file a retrial? You cannot do. That is also a bar under Article 20 of the Constitution of India, read with the Section 300 CRPC, and in the Code of Civil Procedure, Section 11 is a bar. So we will deal with both the proceeding. Essentially, Section 40 is dealing with the evidence in the nature of a previous suit having been filed by a party which has been thrown out or maybe decreed, and a subsequent suit, whether it is admissible or not. Secondly, the provisions of Section 300, persons who have been acquitted or tried for the same offense, isn't it? दोनों भी deal करेंगे, both CPC and CRPC. I will give illustration. Yes. Keep your CRPC also with you. Yeah. Section 40 ले लीजिए. Previous judgment relevant to bar a second suit or a trial. Second suit or trial. The existence of any judgment, order, or decree which by law prevents any court from taking cognizance of a suit holding a trial is relevant when the question is whether such a court ought to take cognizance of such a suit or hold the trial. Okay, this is now when, yes, that is when any judgment, an order or decree or law prevents any court from taking cognizance of a suit holding a trial in a question arising such a court order. Now, you know that, now take for example, section 40 lays down when there has been a judgment but about the fact of law, providing that there has been such a judgment, no subsequent proceeding would be may be filed in respect of the same cause of action. Now, finest example is Section 11 of the Code of Civil Procedure. So all of you know that here. Now, Section 11 जरा खोल लेंगे आप. Just I will recapitulate. Of course, all of you know what is Section 11. That is dealing with res judicata. No court shall try any suit or issue in which the matter directly or substantially in issue has been directly and substantially in issue in a former suit between the same parties. Number one, between the parties under whom they are the claiming litigant under the same title or a court competent to try. Number two, the try karo. Parties must be same or the legal representatives, or a court must be competent in having jurisdiction. A subsequent suit in such issue has been raised, has been heard and finally disposed of. So it speaks of heard and finally disposed of mean all of you know that here the court must have framed issues. The trial must have taken place. And not basically an ex parte order or a judgment or where the court has not framed issues or given a finding. There must be a finality in the matter. Only when final order and judgments are passed by the court of law on merits, a subsequent suit is barred. So Section 40, so previous judgment are relevant. So suppose, for example, the father or grandfather of A had filed a suit for a declaration against B that you are a trespasser. And B should be liable to be evicted. B took up the plea that he is not a trespasser. He has been in possession for several years and has acquired the status of a prescription, that is a adverse possession under Article 65 of the Limitation Act, and he's become an owner by adverse possession. So he's become an owner by adverse possession because he was in possession for more than 12 years, and before being in possession, more than 20 years have elapsed. After 20 years, the plaintiff is filing a suit under the provisions of Article 20, Section 26 of the 27 of the Limitation Act. If the legal owner does not take action against the unlawful occupant for 12 years, his rights are extinguished. But in आपने Section 27 खोलिए of the Limitation Act. Extinguished Section 27 खोल लीजिए, just come to know. Section 27. I'm not able to see section 27 of the Limitation Act. Just open it. I will open and read it for you. I will read section 27. I have got a copy here. Extinguishment of the right of to property at the determination of the period hereby to any person for instituting a suit for possession of any property, his right to property shall be extinguished. Now, a right to property, you have to file a suit within 12 years under Article 66 and 67. You should know these provisions very well. If you want to succeed and practice law in the court. Article 66, possession of immovable property, 12 years. Then again, by landlord to recover possession, 12 years. अगर 12 years के अंदर आप सूट नहीं फाइल करें, and if you are a government of India, within 30 years, you are not filed a suit, mortgagee suit, 30 years, that is Article 63, then the suit is likely to be barred under Section 27 of the Limitation Act. Then what does the trespasser will take up the plea? His right will be accrued from the day it become adverse. That is Article 64 and 65. Check करें आप. Possession of immovable property based on previous possession and not on title when the plaintiff possession has become dispossessed, 12 years. Then Article 65 check करें. When the possession of the defendant becomes adverse to plaintiff. So adverse possession का suit can be filed within 12 years. Now the Supreme Court of India in the year 2019 has held that it is not only the defendant can claim adverse possession, even can plaintiff file a suit. That is a interesting judgment of the 3-bench judges of the Supreme Court. Please check it up. Arising from Punjab, overruling the earlier judgment of this 2 judges of the Supreme Court in Gurudwara Sahib's case. That has been overruled. And the present judgment of the Supreme Court says that here, which is led by Justice Arun Mishra's bench, Arun Mishra, Justice Nazir and Justice M.R. Shah. The latest judgment, even the plaintiff can file a suit for adverse possession within 12 years from the time when his possession becomes adverse against the defendant. So the suit can be, if the real owner doesn't file the suit within 12 years under Section 27 of the Limitation Act, he loses his legal rights. Please note that. So that judgment, subsequently another suit file kar diya between the same parties, unke children. You can show, my lord, already this issue has been foreclosed, a decree has been passed in the matter, and the subsequent suit is a res judicata. So the previous suit you can invoke in the present suit and inform the court. Under Section 40, the court can say that yes, the previous judgment is admissible. Okay, that is one judgment. Then for the purpose of prosecution under 300, the judgment of a previous case is also admissible. If defamation के लिए आपने criminal court में case की under 499, 500, 501, 502, that was, if it is resulted in acquittal or dismissal, the second complaint is barred under Section 300, isn't it? It is based on the same principles of the res judicata under Section 11, and Section 300 CRPC bars you. Now, when you open Section 300 CRPC, you will come to know. I will just go through this 300 CRPC. A person who has once been tried by the court of competent jurisdiction for an offence and convicted on offence shall, when such conviction acquitted, remain in force, not liable to be tried again for the same offence, nor the same fact for any offence for which a different charge against whom might have been framed under 221, for which he might have been convicted under 2. Are provisions of acquittal, conviction so and so, maybe afterwards tried with the conviction so and so. So these are the circumstances given. Number one, both for the purpose of Section 11 and 300, the defense which the other side can take is, number one, the decree which was passed was not by a competent court. And similarly, the prosecution which was tried is not by a competent court of law. So the decree is nullity. The order and judgment which has been passed cannot be applied to. For example, a court of small causes court has passed a decree that A is a trespasser. The court of small causes is not competent to pass a decree of trespass. There is a bar under section 19 of the Presidency Small Cause Court Act. Similarly, the court of the magistrate, judicial magistrate first class or second class cannot try an offense of robbery or rape, which is a session triable case. And you can take up the plea that here the judgment which has been relied upon is not binding. But if it is the judgment with regard to murder or rape is passed by the court of session, a competent court, a second charges cannot be levied against him. There is a bar under section 300. Similarly, if a civil court under section 9, which has been described, is a civil court which has passed a decree, a final decree, declaring that B, that he is a trespasser, or he has acquired the status of the adverse possession, the ownership of prescription under Article 64, 65 of the Limitation Act. It's a civil court competent to pass a decree, and such a decree is binding upon the parties in subsequent proceedings that may be filed on the same ground or similarly substantially same ground. That is the language of. So section 41 of the Evidence Act will be attracted. So when you seek to tender, when the plaintiff will seek to, the plaintiff is examining the case, my lord, this was the previous judgment, not binding. The defendant will take up the plea. The present suit is not maintainable, hit by section 11. I produce the previous judgment. So the defendant, the plaintiff cannot oppose it. The previous judgment, the judgment given in the earlier case is relevant judgment, and the court is entitled to take into consideration and mark it as exhibit and read the same. Apart from the fact that even the plain written statement affidavit can also be used in the subsequent suit, taking recourse to the provisions of section 33 earlier, provided the witnesses had undergone cross-examination. So you can use both section 41 as well as section 33. So even under 11, res judicata cannot be, the court is not going to invoke the provisions of section 11 unless the decree was passed on merit. Please note that. Merely because it is an ex parte decree where the summons was served, defendant did not remain present, the ex parte decree, defendant did not challenge, not file written statement, it's a weak judgment. तो उसके ऊपर मेरे ख्याल से रेस जुडिकेटा may not be applicable. So you cannot take up the plea that the previous suit is a suit on merits. So there are many Supreme Court judgments to that effect here. In order to invoke the provisions of section 11 res judicata, the decree must have been passed on merits by framing issues, by examining parties. Parties must have undergone cross-examination, the rigors of cross-examination. It's a final order. A decree is a final order under section 2 of the CPC. It is not an interlocutory order. Just an order case the plaintiff, defendant absent, suit to proceed ex parte, suit decreed. That is not an order, not a decree on merits. So for the purpose of section 40, previous judgment is relevant in this matter here. That is what the provisions of law say that here. Okay, anybody want to ask any question on section 40? Please go ahead. I am now shifting to section 41, which was already discussed, but to recapitulate your memory and once again read it and explain to you for those students who did not remain present last time. Section 41 पे आ जाइए. So यहाँ पे 40 हो गया. 40 के लिए again you have to know the meaning of what is judgments in rem, judgments in personam. Judgments in rem are binding on the everybody, the entire world. The legal status of somebody is decided, is affecting the legal status. A and B have been divorced. So it is the entire world is supposed to know matrimonial proceeding and the divorce हो गया है. So when divorce हो गया है, तो none of these spouses after the death of each other can claim their property under these succession laws. समझे ना आप? So the entire world is supposed to take cognizance of it. Whereas judgment in personam or ordinary judgment affecting the status of the parties who are parties to the proceeding. It may be a declaratory suit by A and B that particular deed is illegal, rectification of a deed, that the document is sham, colorable, bogus, to be set aside, that the partition be effected between A and B. These are judgment in personam, which is applicable to the parties who are to the suit now. Okay. Anybody wants to ask me any question on section 40? I am shifting to section 41. So section 40 is applicable to both civil cases and criminal cases. Please note that there is no distinction. Now section 41 में आ जाइए. Section 41, I will keep the CRPC aside. Now Evidence Act पे concentrate करें. Yes. Relevancy of certain judgments in probate, etc. of jurisdiction. Now यहाँ पे is very important. That is, it should be a final judgment. See, a final judgment is recorded by the court when pleadings are completed, when issues are framed, both the parties have led evidence and both the parties had opportunity to cross-examine each other witnesses. So then only it becomes a final judgment. Final judgment, order or decree of a competent court. See, some of the high courts in India, they don't record evidence at the time when a final judgment is passed in insolvency cases. I have seen, at least I have argued several of the insolvency cases in Bombay High Court under the Presidency Towns Insolvency Act, and in Mufassil areas it is a Pune like this. This is a provincial act. So normally the High Court doesn't record evidence. So when they doesn't record evidence, High Court is normally going by the record. But the parties have a right to insist and say that I would like to cross-examine witnesses. There is a gentleman call under the High Court rules, official assignee before whom the matter is assigned. You have a right to cross-examine the creditors, debtors, and insolvent and elicit as much evidence. Then judgment, order, and decree. Now, what is the judgment and order decree? CPC के अंदर पढ़े हैं. I do not want to explain to you. Of a competent court, underline the word competent court. So, the final judgment decree of a competent in expect probate. Under the Indian Succession Act, probate is granted by the district judge, a district court. For the purpose of city like Bombay, where there is no district court, the High Court exercising jurisdiction OOCJ के अंदर is a district court. Please note that Bombay High Court exercising jurisdiction under the ordinary original civil jurisdiction under clause 12 of the letters patent entertaining directly suit, that is called is a district court. And Thane mein, Kalyan mein, Pune mein district court hai. If your grandfather has left behind a will, probate is required to be obtained. You cannot go to the small causes court or a magistrate court to grant probate. You have to go to the district court. So under the Succession Act, the word used is to probate to be obtained from a district court. Underline the word. A district court in the city of Bombay is a Bombay High Court. And other places is the district court. Like under the provisions of section 96, an appeal lies to the High Court or a district court. So there's a thin distinction between this here. Cities like Bombay, Calcutta, and Delhi ke andar to there is a district court separately, despite the fact that Delhi High Court entertains directly some suits. वो अलग बात है. Under it all depends upon the letters patent. So a probate is granted in city of Bombay by the Bombay High Court, original side, not by the appellate side, not by the criminal side, not by any other side. It is under the ordinary original civil jurisdiction, testamentary. They are called TS suits. Testamentary suits और testamentary suit के अंदर when parties are litigating under the Indian Succession Act, a probate is issued. Section 263 is the relevant section. All of you know that here, उसके अंदर दिया गया. Okay. Then matrimonial decrees. Now, matrimonial decrees were earlier being passed under the Hindu Succession Act. Suit is filed under Section 9 of the Code of Civil Procedure because it is a suit of a civil nature. Hama Act के अंदर. But now with the passing of the Family Court Act, Section 7 of the Family Code said that Family Court shall have exclusive jurisdiction in the matter of divorce, in the matter of custody, in the matter of maintenance between the parties to the marriage. I mean husband and wife. Usme in-laws and somebody else is involved, property, you have to go to the civil court. Isn't it? If it is a joint property of a husband and wife, the family court can pass orders. Family court can pass orders with regard to divorce, judicial separation, and custody of children. All. So, a matrimonial court ki decree is passed between the parties that the marriage has been dissolved. It is supposed to be a judgment which is called conclusive evidence. It's a judgment in rem, binding on the entire world, unless fraud is established. Number 3, admiralty. Now, city like Bombay, Calcutta, Madras, these are the high courts, which are also known as by the East India Company. What they are known as? Anybody knows? What are these high court known as? Bombay, Calcutta, Madras. CPC में पढ़े हाँ जी.
So chartered high courts.
Chartered
high courts, yes.
They were known as chartered.
So under the Indian High Courts Act 1861, पढ़िए आप उसके अंदर, the Bombay, Calcutta, Madras High Court are the one which were established after the Supreme Court, which was earlier in existence. Under the Regulating Act, there was a Supreme Court in Delhi, Calcutta, and Madras. Under the Lord Warren Hastings reforms. That the Chief Justice Impe was excommunicated for reason some felony has committed. Then the Supreme Court were abolished. Then the High Courts Act came into picture. The Bombay, Calcutta. The first High Court which was established was the Calcutta High Court. Second was the Madras High Court. Then subsequently Bombay High Court. Bombay High Court 1862, 1861, Calcutta and Madras High Court. And Fort William High Court it is known as. So these are the high courts which are given admiralty powers because यहाँ पे shipyard है, isn't it? यहाँ पे ship है, foreign ship आएगी, आपने कुछ goods मंगाए, वो deliver नहीं किया, it can be confiscated. The court will immediately pass ex parte decree under the admiralty rules. Ship को अंदर कर दो, ship को stop करा दो. Shipping company के owner ने आपसे माल लिया, you have to send consignment to America, London, Dubai, उन्होंने आपको नहीं भेजा, ship में problem आ गया. Or a gentleman, a ship captain will say in Mumbai, मेरे पगार नहीं मिला 3 महीने से, the ship owner is not paying me, and he has a right to file a suit on admiralty and get the ship arrested. I appeared in many such matters, and many of you must be seeing that here. So normally the court ex parte without notice to other side will stop the ship and give notice to the master of the ship and the company, tell why your ship should not be arrested in the waters of Mumbai, Calcutta. So here also evidence is recorded. Ultimately, these matters are settled basically. These are commercial causes basically. So when a decree which is passed, final order and decree by the court, whether recording evidence and not recording. So normally the High Court doesn't like to record evidence here. Parties execute a final order. An order is also passed by consent of the parties. It becomes a final order, and it's a conclusive evidence under the law. It's binding on the entire world, and you can put in execution. Everybody can take notice. A third party cannot come say that I had no notice. So the court has passed a probate order. Probate judgment has been given. You cannot challenge it. any person who is agreed by the probate, probate is only establishing that the will contains a signature of the deceased person. But the proceedings and probate proceedings will not be affecting the substantive right of the parties. You may file a declaration that you have purchased the property from the deceased person. There is an agreement of sale is subsisting. You can go for a suit for specific performance under the specific relief act. There is no bar. That is a suit for title. Suit for title is always open. Please note that. Merely because the district court or high court in Bombay granted you probate, and the person having a legal right to the property can file a suit for a declaration that the proceedings in probate are not binding on you, because prior to the death, the gentleman had entered into with me agreement of sale under section 54 of the Transfer of Property Act. I have a right to file a suit under section 10 and 14 of the 12, 13 of the specific relief act and enforce my right. Under 15, you can file it party to the proceeding and the person claiming under him. No, section 15 is of the specific relief act is very clear in that regard. You know that here any person can file it, a person claiming through it here. So in that event, you can take up the plea that here I have nothing to do with the probate, but he had no capacity to give it to other person because his rights were transferred to me by virtue of the agreement of sale. So your suit will be title suit. Okay, number one. Or insolvency jurisdiction. See that here, number one is a probate jurisdiction with the district court grants it. In matrimonial, with now the family court grants it. Now in the city of Bombay, the High Court is excluded from trying matrimonial cases except the Parsi matrimonial cases where the jury system is prevailing. Okay, remember that here. All other matters are going to the family court now by virtue of section 7 of the family court act. Admiralty jurisdiction is still vested with the High Court because the chartered high courts, Bombay, Calcutta, Madras, and high courts who are having a C, maybe by letters patent they can also invoke. For example, the Andhra Pradesh High Court having that they can do that any high court. I'm sure all the high courts must have amended the letters patent to invoke and have the admiralty jurisdiction. Okay, then insolvency jurisdiction. Formerly, it was with the district court in the city of Bombay. The Bombay High Court was trying insolvency. Now, with the passing of NCLT, company law ke liye, yahan pe chal insolvency jurisdiction now of the company and partnership comes, and the companies are going to the NCLT, that is company law board, and some matters are going to the DRT, debt recovery tribunal, of the individuals. Individual matters under the act are going to the debt recovery tribunal. You please note that here. So the high court is not presently, or a district court is, because a special court is, special tribunals are set up now. Now tribunals normally they don't record evidence unless you make a specific application to the tribunal member that I would like to record evidence, because the Evidence Act is excluded from the tribunals unless specifically given authority. So when the tribunals having been given power in insolvency jurisdiction, that remains to be seen what is the effect of the judgment given by those tribunals under section 41, because the tribunal does not have power to record evidence, because under the provisions of section 1 of the Evidence Act, arbitrators and tribunals are not within the purview. They are not judicial proceeding. Unless the word it is mentioned, they are recording judicial proceeding. Some of the tribunals are mentioning it. Like motor accident tribunal is a judicial proceeding, though it's a tribunal recording evidence. Some tribunals are invested. I am sure even the DRT is invested with power of a judicial proceeding, and also NCLT trying matters under the Companies Act. They are invested with those powers here. So the judgments given by these tribunals and the courts are conclusive evidence by virtue of section 41. See that here? Let us see. A final judgment and order and decree of a competent court in the exercise of a probate, matrimonial, admiralty, insolvency jurisdiction, which confers upon, takes away from any person any legal character, or which declares any person to be entitled to such character, or be entitled to any specific thing, not as against any specified person, but absolutely relevant They are relevant when the existence of such legal character title of the person is relevant. So section 41 can be invoked. Such judgment decree is conclusive proof. That is section 4 के अंदर पर may presume, shall presume, unconclusive proof. This is one section which introduces the conclusive proof of this section. Then that the legal character which confers accused at the time, accrued at the time when such judgment and order decree came into operation, that the legal character to which it declares any such person to be entitled accrued to that person at the time as the judgment and order decree, so and so, that the legal character which it takes away from that person ceases at the time decree declared that ceases, that anything to which declares any person to be so declared was the property that person from which judgment and order that decree that has been should be his property. So the court takes into cognizance that when the judgment and decree of these four courts is brought before the court of law, it is not open for you to challenge. There is no need to produce rebuttal evidence unless you take up the plea that fraud has been played. When you take up the plea that husband and wife have taken a decree from the family court on the ground that their relationship are strained, बाद में मालूम हुआ कि the lady who was brought to the family court is not his real wife, she is his mistress. Then the real wife files a suit for declaration that it is a bogus. So under section 44, you have a right to challenge fraud has been committed. मैं उसके ऊपर आऊंगा. Or when decree is passed, that judgment is a judgment in rem which is binding on the entire world. Okay, this is one. How 40 is applicable in cases of under section 11 CPC and 300 CRPC. For illustration, 41 के illustrations are given here. Final judgment decree in the case of probate case, matrimonial, admiralty, insolvency courts, how they are conclusive. You are not permitted to lead rebuttal in evidence except in fraudulent cases. Now the third topic is relevancy and affect the judgment of orders or decree other than those mentioned in 41. So now the 41 speaks of judgments in rem. Now this section speaks of 42 judgments in personam. Okay, other mean the personam mean between the same parties, between the parties, it's an ordinary judgment. It's an ordinary judgment between the parties. A judgment and order and decree other than those mentioned in section 41 are relevant if they relate to matters of public nature. Underline this word here. Judgment and order decree other than those mentioned in 41. That means you have to exclude the judgment in probate court, judgment of matrimonial court, judgment in admiralty court, insolvency court. A चार judgment छोड़ के other judgments are relevant if they relate to matters of public nature. Public nature means it can also be a suit between third parties. So there may be a suit between A and B stating that you cannot encroach upon my land. A tells B, look here, you should not do construction and I have a right of way to go from your land to the mandira, masjid or gurudwara which is situated. I have a easementary right. So third parties ke right be involved. Yeah, yes, section is interesting. So that judgment which is passed under section 42, so it is of a public nature. So even third parties' rights, because for the purpose of invoking 40, 41, parties must be same. 40 ke liye. If the parties are not same, third parties ke liye it cannot be invoked. It must be between the same parties or their representative in interest. Their heirs and legal representatives. But it cannot be against strangers. But 42 covers cases not only the parties but also third parties. That means a third party, I am a third party, I do not have any interest in your land. But you are trying to put up some construction on the land which is adjacent to the path, right? Public way, which the general public has a right. They have a right to object. They will say we have a easementary right. So when such judgments are given relevant to the inquiry, but such judgment, order, decree are not conclusive proof of which they are stated. So though the judgment may be relevant, but they are not conclusive proof. you have a right of rebuttal. You may dislodge the suit filed by Mr. Shah claiming to be having easementary right is a bogus suit. It's a fraudulent, it's a fictitious suit. He doesn't have any right title interest. You have a right to challenge it. But whereas under 41, you cannot challenge on the ground that the judgment given by the High Court in insolvency proceeding not binding upon me. I am one of the creditor. I will go in execution, execute decree. Arey, High Court ने declare किया है, A is insolvent, he is kadka. He has taken loan from hundreds of people. There were 100 decrees were passed. So he has come to the High Court, grant a declaration that I am insolvent. Insolvency proceeding के अंदर court is pass a decree under the Insolvency Act. So tomorrow I and you cannot file a suit in city civil court or small causes court, obtain decree and execute against him. You cannot execute against an insolvent. You without the permission of the court, or you have to go against the official assignee. When a decree is passed, it is coming in newspaper. It's a judgment in rem. सारे दुनिया को पता चला हुआ है. So my decree is ineffective. Whatever decree I obtain against the insolvent is not binding. समझे ना आप? That is the meaning. Whereas in 42 cases, a third party may take up the plea. I have a easementary right in respect of the land of A, the owner, and there is a previous suit filed by my predecessor against him. That judgment is pending. That judgment is relevant, you can show. Under 42. Okay. Now let us see the illustration to understand it. A sues B for trespass on his land. So A sues B for trespass on land. So land belongs to A. B is trespassing. B alleges the existence of a public right, like I told you, public right of way over the land, which he denies. So the B will take up the plea. I have a easementary right, right of prescription. For centuries, donkeys, years, the public is owing on the land, and you cannot, your action of trespass against me is illegal. No, then the existence of a decree in favor of the defendant. Defendant will take up the plea. The present suit for declaration of trespass is not maintainable because already in the year 1950 or 60, the Honorable Civil Court or High Court has passed an order under Section 92 of the Code of Civil Procedure when a public nuisance was a suit filed in which the court declared that it is the general public has a right to go. So there's a temple situated here for going to the temple, and we have a right to use the way, the land of A. Then see the existence of a decree of the defendant in a suit by A against C for trespass on the same land in which C alleged existent right of way is relevant. So if the defendant brings unto the court, my lord, such a decree is passed, such a judgment is passed previously by the other court, in a competent court, in a suit which was filed for a mandatory injunction or a perpetual injunction under Section 39 of the specific effect, that decree is binding. So where is the question of trespass? So the trespass action is illegal. So यहाँ पे it is not conclusive, but it is relevant. It is not conclusive, but A may take up the plea, though there is a judgment in his favor in the year 1950. Now, consequently, there are certain amendments have taken place. There are change of circumstances. Change of circumstances in such a way the conditions have been put up. That right is only available for a period of 10 years, 20 years. And whereas the present defendant has come into possession recently, the land was acquired by the government, and after acquisition, compensation was paid, solution was paid. These are the rights you can challenge. So the previous judgment which is sought to be relied upon may be relevant, but not binding on me. The court may be relevant if in those days. Subsequent events have flown. So my suit for trespass against him is maintainable, should be decided. So rival contention, A will argue in that way, B will say that here, on account of the existence of the previous judgment, which is relevant, the present suit is not maintainable. So that is what exactly is how the court, you are introducing in the court your judgment whether it is relevant or not. I am on the point of relevancy and admissibility. I am not in the point of whether the court should dismiss your suit or allow the suit. Oh, that is a different thing. Because at the time when you suits are filed and evidence in chief is filed or by both the parties, the matter is kept for admissibility and relevance denial of documents. So that is a stage which is coming under section 135, 136 of the Evidence Act, which I told you. So denial and admissibility, which is read with section order 13 of the Code of Civil Procedure. At this stage, you have to give your objection. My lord, I admit this document, I do not admit this. So the defendant is producing the judgment, the plaintiff may say this is not relevant. Defendant will say it is a relevant judgment under section 42. So this is the finding which the court will record under section 136, which I would like to again recapitulate and draw your attention to 136, how the court passes the relevancy and admissibility. Just please pay. Just to decide, see, judge to decide admissibility of evidence. When either party proposes to give evidence of any fact, judge may ask the party proposing to give the evidence in the manner the alleged fact and proved would be relevant, and the judge will admit the evidence if he thinks the fact proved and would be relevant and not otherwise. So the learned judge will record his finding. The order copy which is produced by the defendant in the previous suit, in my opinion, has been produced which the plaintiff is refuting and has not given consent for admission. Now, the admission and denial are decided by the court under 135, read with order 13. 13 ko liya aapne? This is how you utilize your Evidence Act and CRPC and the CPC in the court of law. Please note that. Then यहाँ देखिए, order 13, rule 3, rejection of irrelevant or inadmissible evidence. So the court ने यहाँ पे order 13 rule 1 के अंदर parties, pleaders produce before the court settlement of issue all documentary evidence in original. So the court shall receive the evidence so produced, provided they are compared, accurate list is prepared. ये list बनाएंगे, present करेंगे आप. Then the court will either under 136 of the Evidence Act will give judgment. If the court is rejecting, the court may at any stage of the suit reject any document considers irrelevant or otherwise inadmissible and record the ground for rejection. The court is bound to record and give reason why we are not admitting it, number one. Then order 13 rule 4 says endorsement on document admitted in evidence. So the order is passed under 136 of the Evidence Act. I heard both the parties. Defendant has produced the judgment. Plaintiff is refusing. Now, subject to the provisions of next following, there shall be endorsement on the document which has been admitted. So the court will say that I am satisfied that this judgment is relevant for the purpose of section 42 of the Evidence Act. So I therefore admit the evidence. So order 13 rule 4 के अंदर Judge Sahab will pass the order. This evidence you should know, that is how you are connecting the Evidence Act with the Code of Civil Procedure and admissibility in the court of law. Please note that here. So यहाँ पे section 42 के हिसाब से that judgment may not be conclusive. It's not binding upon the entire world. Third parties भी कर सकते हैं, between the same parties also may take up the plea that the court has passed an order that A is a trespasser, B has taken up the plea, I am a deemed tenant or a irrevocable licensee. The judgment can be produced by the court. So the subsequent suit is not maintainable because the court has recorded a finding in my favor that I have an irrevocable license to use the premises. So the judgment becomes relevant for the purpose of section 42. It is between the same parties or between the representative in interest between the parties. Okay, anybody want any question before I shift to section 43? Please ask me any question. Then I will take 43 and 44 पे stop करने वाला हूँ. Two judgments. Anybody has any question? Please ask me. Now, section 43 is more tricky. Section 43 is more interesting and more tricky and more confusing, which I will dispel all the tricks. Don't worry here. Yeah. Judgments, etc. Judgments, etc., other than those mentioned in 40 to 42. 40, 41, 42 छोड़ के अभी section 40 में पढ़ लिया आपने. Judgment between the same parties where res judicata is invoked or the provisions of section 300 CRPC are invoked, उसके बारे में बातचीत नहीं हो रही. And 41, that is a conclusive nature, उसके बारे में नहीं होती. And 42, where the judgment is relevant between where the judgment is relevant between the third parties, where a finding is recorded in favor of a third party. How it is relevant? वो छोड़ के other judgments. So when relevant, judgment orders and decrees other than those mentioned in section 40, 41, 42 are irrelevant. So the law makes it here clear that you are not supposed to rely upon any judgment except which are used in section 40. Yeah, section 40 deals with judgment rendering the matter conclusive between the same parties, which we read. 41 deals with judgment which are judgments in rem, abhi padhe humne, now which are conclusive against all the entire world. 41 is binding on the entire world. Then 42 deals with judgment which relating to matter of a public nature. So abhi aapne discuss kiya humne, in a public nature suit which is filed maybe under section 92 of the Code of Civil Procedure, nuisance ke bare mein, or easementary right under section 20, or specific relief act ke andar, or perpetual order of injunction is sought in some nature. So it's a public nature suit you deal with, are relevant though they are not conclusive. What is conclusive is only judgment rendered under section 41. Yeah, then that is between the, that is a section 40. अभी हमने पढ़े जो section 42, it is a suit even between strangers, stranger to the suit. Section 43 lays down a general rule that all judgment and decrees are not, which are not mentioned in section 40 to 42 are irrelevant. So दूसरे judgment are irrelevant. Now what are those judgments? We'll see. To this general rule, a rule of exclusion, the general rule of exclusion is covered under section 43, provide the two exceptions. However, there are two exceptions to this. Let us see the exception. Number one, the judgment and decree orders not relevant under these three preceding sections. They become relevant, number one, when the existence of the judgment and order decree is in fact in issue. Underline this word. Number one, see, irrelevant unless, underline this word, unless the existence of the judgment and order or decree is a fact in issue. The learned judge has framed an issue under order 14 of the Code of Civil Procedure, a suit for declaration, that the agreement is sham, colorable and bogus, and not binding upon the plaintiff. A suit for declaration that the agreement needs rectification under the provisions of section 26 of the Specific Relief Act. A rectification that the properties of the plaintiffs are not shown for some reason in the agreement of sale. The fraud has been committed by the defendant at the time of the execution. The plaintiff has purchased 10 guntas, whereas the defendant has fraudulently or mistakenly shown only 8 guntas. So you go for rectification of the deed itself that is provided under section 26 of the Specific Relief Act. So you seek a declaration, or if you're a third party that the document is affecting your legal right, it's a sham, colorable, bogus document. Be set aside. It's a bogus document. It is my property has been wrongly included. So under the provisions of the Specific Relief Act, you go for it. You have a right to lead evidence. Section 99 of the Evidence Act permits you, a third party can lead evidence to vary the agreement between A and B. You are C. C will say, how can my property be affected? It's a sham transaction between A and B. They are trying to usurp my property. I am not be sit here. So that must be a fact in issue. A previous judgment which has been rendered must be connected to the subsequent judgment. Okay. So यहाँ पे this is one exception which is fact in issue. Number two, or relevant under some other provisions of this act. So it is kept open in a very blanket manner. So the other 43 completely puts a blanket, a general rule of exclusion. You may say that, providing that two exceptions, the judgment and decrees and orders not relevant under the three preceding section, that is the preceding section 41, 42, 43, unless number one, the existence of the judgment and order is a fact in issue. Number two, when judgment and decree is relevant under some other provisions of the act. Some other provisions of the act mean Evidence Act. Now, it is very interesting here. This you can only understand from the illustration, and I will give you a couple of judgment in this matter. Which are there? ये अभी illustration देखिए आप. To understand this, A and B separately sue C for libel, which reflects upon each of them. A libel is a kind of a defamation which is in printing, isn't it? A and B separately sue C. The separate suit is filed for defamation, maybe for claiming damages against C, reflecting upon each of them. So there are two separate suits or proceedings. C in each of these cases say that the matter alleged to be libelous is true. Now there's an admission on the part of C, C on the part, and the circumstances are such that it is probably true in each case or in neither. So यहाँ पे admission with regard by C in each case says the matter alleged libelous is true, and the circumstances are such it is probably true in each case or in neither. Then A obtains a decree against C for damages on the ground that C failed to make out his justification. So a suit is filed for damages under section 73 of the Indian Contract Act or under the law of tort against him on the ground that C failed to make out his justification. His justification means then the fact is irrelevant as between B and C. Now here the fact is irrelevant between B and C because in a suit which has been filed by A, the issues are different. Now he is seeking damages on the ground of justification is not sought, not on the ground that libel took place. So when the issues are different, issues are not common. In order to admit this, in order to invoke or permit the judgment to be part of the record, admissibility and relevancy under section 136 and under the provisions of order 13 rule 1 and 2, the issues must be same. Section 43 cannot be read in isolation. So the court says that the previous judgment, the issues must be same than in the connecting subsequent suit. तो यहाँ पे दोनों में issues अलग अलग हैं, इसीलिए the judgment is irrelevant. B. A prosecutes B for adultery with C, A's wife. Very interesting. Of course, abhi adultery is no more an offense, but previous ki baat hai. A prosecutes B for adultery with C, A's wife. So this was an offense prior to the year that is a prosecution. Open your IPC 498, na it is. Yeah, adultery 497. That is which has been set aside by the Supreme Court in Joseph Shine's case in the year 2018. So this we will take it that this is prior to the year Joseph Stein's case. That is, Supreme Court overruled the judgment of the Supreme Court in Soumitra Vishnu's case. Then, yes. Then, yeah, I will explain this. A prosecutes B for adultery under 497 with C's wife, with C A's wife. B denies. Kindly see that here the respondent accused, B denies that C is C's wife. B denies that C is A's wife. He says she is not your wife. That means your prosecuting me is wrong. In those days, a woman cannot be prosecuted. You knew that, yeah? Only a man could be prosecuted for the offense under 497. But the court convicts B for adultery. So the evidence has come before the court that the offense of adultery has been committed under 497. Then afterwards, C is prosecuted for bigamy. See, mean the gentleman husband is filing a suit against his own wife under 494. So marrying somebody during the lifetime of husband, bigamy. In marrying B during A's lifetime. That is an offense under the provisions of section 494 IPC, which is still on the statute book, which attracts 7 years punishment. Afterwards, C is prosecuted for bigamy in marrying B in A's lifetime. That means her husband has prosecuted her. C says she never was A's wife. So the earlier judgment was that in an adultery case under 497, her paramour was convicted. Underline this word. Of course, the wife could not be prosecuted in the earlier days. Now, subsequently, the husband is now taking revenge. She left him probably and she married his friend B during a lifetime. So, prosecution is launched under 494. It's a second case. Wife. The judgment against B is irrelevant against C. See, interesting. The judgment against B means earlier case was tried for adultery under 497. That was the issue. Now the second case is for bigamy under 494. The issues are different. The charges are different. So the previous judgment where B was convicted for having an affair with his wife is not valid, cannot be useful for Mr. A when he is prosecuting his wife for bigamy under 494, because the charges are different, issues are different. Because section 43 says that those mentioned in 4042 are irrelevant unless the exists a judgment, an order and decree is a fact in issue. So the charge under section 494 was not the fact in issue in the former suit. The former suit ke andar what was in issue? What was in issue?
Adultery.
497, which is adultery. Adultery attracted only 5 years punishment in those days. So, wo suit, in that there was a conviction order against B. वो conviction होने के बाद probably B and C became good friends. She married each other. So naturally A is bugged. In retaliation, what he does, he files a criminal prosecution under 494 for bigamy. तो तुमने जो शादी की है without taking divorce from me, It's illegal. Such many things are happening. So A will not be permitted to use the earlier judgment in the subsequent judgment because the issues were different. Understood? For the purpose of 43, the earlier judgment between the same parties may be on different issues. They are not in fact in issue. Perjury, adultery is a different ground, and the provisions of 494 are different. So that cannot be used. For the purpose of section B, the court will not allow the judgment to be used, and under 136 of the Evidence Act, the court will say judgment not relevant, not admissible. And an order will be passed under Order 13, Rule 4 CPC, document rejected. Okay, now let us see the next example. Yes. See, A prosecutes B for stealing a cow from him. See, A prosecutes B for stealing a cow. That is an offense of theft under section 379, 380 IPC. A prosecutes B for stealing cow from him. B is convicted. यहाँ पे B के खिलाफ charges लगे. Afterwards, A sues C for the cow which B had sold to him before his conviction. यहाँ पे देखिए, A afterwards sues C for the cow which B had sold him before his conviction. यहाँ पे sale had been taken place of the very same cow in respect of which stealing charge was proved. As between A and C, the judgment against B is irrelevant. So यहाँ पे the judgment is irrelevant because the first earlier charge was with regard to theft under 379, 380 of the Indian Penal Code. Isn't it good? And second charge was that afterwards sues which has been sold to convincingly as between and judgment against B irrelevant. So A afterwards sues B for cow. Now he is filing a suit for restoration of the cow. For restoration of the cow may be a mandatory order he is seeking under section 38 of the Specific Relief Act, which is a different issues. A criminal court may conviction under 379 of the Indian Penal Code is a different altogether issue. So the judgment, you cannot be permitted to rely upon the judgment of a criminal court under section 379 for the purpose of Specific Relief Act section 38. So the judgment is will not be accepted by the court. Now let us see in what case it can be accepted. Yes. D. A has obtained a decree for possession of land against B in a suit for possession, or maybe under Article 66 or 67. A has obtained a decree for possession of land against B. C, B's son murders A in consequence. Interesting. A has obtained decree of eviction against B. That means B will be dispossessed. Unki family will be without possession. C, naturally he is infuriated. उसको गुस्सा आ गया, मेरे बाप के खिलाफ तुमने डिग्री ले लिया, मेरी माँ का और मेरा क्या होगा? तो जोश में आके उन्होंने ए की हत्या कर दी. It's a civil suit which is decrees passed by a civil court, now converted into a criminal offense under 300 of the Indian Penal Code. Now let us see. The existence of a judgment is relevant. Now can in a murder case, earlier हमने केस किए 379 के अंदर वो गाय भैंस को उसने चोरी किया, isn't it? The court convicted him under 379 when he filed a civil suit for restoration of the guy. The judgment is not binding. But यहाँ पे the court says the existence of a judgment in a civil court is relevant as showing motive for crime. So the reason he committed hatya of Mr. A, C, the son of B, committed the murder of A, his landlord, because his father, who was a tenant, was evicted by A. So C, the son, murders the landlord A. So whether the judgment given by the civil court, by the court of small causes court, or a city civil court, or a high court, or any civil judge senior division, with regard to decree of eviction, can it be produced by the prosecution in a murder case under 302? Yes, because that was the motive behind. The reason for committing the murder is that they were evicted by A. C, in retaliation, there was a motive, preparation and conduct. Now, under the provisions of section 8, motive, preparation, conduct is relevant. Please read section 8. 8 में आ जाइए आप of the Evidence Act. पढ़े ना 8 में? Motive, preparation and previous subsequent conduct. Any fact is relevant which shows or constitute a motive, preparation for any conduct in issue relevant. So section 33 trace, अभी देखो अभी हमने पढ़े आपको, is very important. See, section 33 says judgment etc. other than mentioned in 40 to 43 when relevant. Judgment, order, decree other than those mentioned in 40, 41 are irrelevant unless the existence of such judgment and order, decree is in fact in issue. In earlier case में बताया हमने fact in issue को, or relevant under some other provisions of this act. So under section 8, the motive is relevant. A having committed the murder of the landlord, the reason for committing the murder is that the landlord had obtained a decree from a civil court of his father who was a tenant. So in a criminal prosecution, the public prosecutor can show there was the reason why A committed, the accused committed the murder of his landlord because the landlord had filed a suit for eviction of a premises where they were staying and his father was evicted. As an act of retaliation, he was harboring a motive. Motive, preparation. Under section 8, motive is a relevant fact. So the existence of a judgment of a civil court passing a decree of eviction is relevant under section 43. समझ में आ गया? Understood? Understood or not?
Understood, sir.
Yeah, last judgment, last illustration. Sorry, second last. A is charged with theft and with having been previously convicted of theft. So यहाँ पे 379, 380 is the charge. चोरी का इल्जाम किया गया उनको. A is charged with theft and with having been previously convicted of theft. So इससे पहले भी उसने चोरी किया था. So there are two judgments against him, operating against him on the same charges. That is section 380 of the Indian Penal Code. आप खोल के देखें 379, 380. For your ready reference, I'll just open and show you theft ka section. All of you know it is. Yeah, 379. Yeah. Punishment for theft 379, which attracts a punishment of 3 years. Okay. This is he was convicted under section following illustration E में देख रहा हूं. A is charged with theft with having been previously convicted of that. That means On one occasion, he was charged under 379, maybe having robbed a mobile phone in ladies' compartment. And second charge, again under 379, having robbed jewelry in the ladies' compartment of a different train subsequently. Now, the previous conviction is relevant as a fact in issue. Why this is judgment is relevant? Because previous judgment under 43, it clearly says it's a judgment which is fact in issue. In both the judgment, what was in issue? Same charges under 379. Similarly, under the previous judgment, the issue was with regard to declaration. Subsequent suit may be declaration. If there are similar charges or similar issues, then the judgment given under 43 will be relevant. Otherwise, okay. This is an example of a such judgment and decree, that means, are irrelevant. All judgment under 40, 41 are irrelevant for 43 unless the existence of a judgment and order or decree is in fact an issue. Number one, or relevant under some other provision. Only in two situations, Section 43 recognized the admissibility of previous judgment. Number one, existence of a previous judgment covering a similar fact in issue as that of an issue in the subsequent proceeding, or any of the provisions of the Indian Evidence Act permits, like in the earlier case of a murder, the motive preparation, conduct, the landlord having taken decree for possession, and in retaliation, the son of the tenant shooting the landlord and killing him, was the motive. That is a mens rea. A mens rea is proved, and hence the existence of a judgment of the civil court can be produced in the criminal proceeding under 300 to prove that that was the reason for murder and he is the person who committed the murder. You are identifying it. And in second judgment, A had committed theft earlier in ladies' compartment and stole the mobile phones of the ladies and sold it to the local banya. He was convicted for 2 years. Judgment is present. And next year again he commits similar offense. And this time he is snatching chain and gold of the ladies or pickpocketing people and selling their laptops. Ye bhi theft aa gaya. So the charge is theft under section 379. So when charges are similar, the existence of a previous judgment is relevant because under the provisions of section 53, character evidence can be brought on record. Please open the provisions of section section 54. Previous bad character not relevant except in reply if he takes up the plea. Also, in criminal cases, previous good character is relevant. Judgment can be shown. Accused also can show that the judge has passed an observation about my character. But if the accused takes up the plea, I am a clean person, I am a man of virtue, a paragon of virtue, I do not have any antecedent. So you can use the previous judgment to show that it is not so. Okay. Not only this here, the court will show the issues. I mean, he is the person in the habit of committing such offenses here. So civil cases, in civil cases, the fact and character of a person is imputed irrelevant, except in such character from the civil cases may irrelevant. In criminal cases may you can show that. 52 is very clear. Character to prove the conduct of a person is irrelevant in civil cases. But to prove the conduct of a man that he is in the habit of committing. In criminal cases, previous good character. In criminal cases proceeding, the fact that the accused person is a good character is also relevant. Then in a prosecution for rape, wala chhod dijiye. Then in criminal proceeding, the fact that the accused person has a bad character is irrelevant unless evidence has been given he has a good character. So you can impeach his credibility under 155(3). So that to show that he is a man whose conduct is very bad. 52 ke andar 52 is protecting only the cases, civil cases. In a criminal case, to show that it is important to show his bad character. Not a bad character, his conduct is not clean. He is a person who is habituated to commit crime. In fact, he was convicted. So the purpose here, the last illustration le lenge abhi. Section 43. Yes. If A is tried for murder of B, the fact that B prosecuted A for libel, A tried for murder, 302 is the charge here. The fact that B prosecuted A for libel and that A was convicted and sentenced is relevant under section 8 as showing the motive. Again, though the issues are different in both the proceeding. So A is tried for murder. यहाँ पे murder serious charges है. The fact that B prosecuted for libel and A was convicted and sentenced is relevant. The reason why in retaliation he murdered him because A had filed a suit for defamation. तुमने मुझ पे defamation case किया है, then मैं जो देख लूंगा. I will not leave you. So the reason why he is committing murder because he was hurt, he was humiliated that you have indulged in a campaign of vilification against me and you have filed a suit against me. How dare you do that? And I will teach you a lesson. So the existence of the former case, the reason why is he committing murder is a mens rea. Under section 8, motive, preparation and conduct is relevant. So for the purpose of illustration F and for the purpose of illustration D, section 8 will come into play, though the charges are different, but it is admissible under the provisions of the Act. But for the purpose of fact in issue, the illustration in where are the illustration? Libelous nature obtains a decree between the same, the fact is irrelevant. Everything is irrelevant here, and what is relevant is here A has obtained a decree and motive for preparation. All other judgments are irrelevant because the issues were different. The issues must be same in order to rely upon. The court should take into record. Otherwise, it is not so. Okay, please note that. This is a very tricky section, 43. Very dicey unless you know the other provisions of the Evidence Act. Unless you apply your mind, you won't understand this. So we'll take a last section, that is section 44. I will stop it here. Fraud or collusion in obtaining a judgment or incompetency of the case may be proved. Any party to a suit or other proceeding may show that any judgment and order decree which is relevant under 40, 41, 42 and which has been proved by the adverse party was delivered by a court not competent to deliver it was obtained by fraud and collusion. So section 41 के अंदर हमने सीखा था अभी a judgment of the High Court in probate, a judgment of the High Court in admiralty and insolvency proceedings and judgment of a family court in matrimonial proceedings are conclusive proof. You will not be permitted to conclusive proof का मतलब you cannot be permitted to rebut lead evidence unless you tell the court this judgment has been obtained fraudulently. Number one, A and B went to the family court pretending to be husband and wife. In fact, that lady was not his wife. The real wife will come into play and make an application for setting aside it. I am the real wife. It is a bogus degree he has taken. So fraud has been played upon the court, set aside the degree. Or a decree has been passed by a magistrate court, which cannot be permitted. That court does not have jurisdiction to pass a decree for divorce. Not that the court of small causes court don't do that. It is only the matrimonial court, either the family court. All the judgments for res judicata he is claiming. A says that he filed a suit for eviction in the city of Bombay for evicting my father and obtained a decree from city civil court. The previous judgment is not binding because that the city civil court had no jurisdiction. It is in fact the court of small causes court under section 33 of the rent control legislation and 28 of the Bombay Rent Act can pass a decree. Civil court cannot pass a decree for landlord and tenant. The decree is not binding. So res judicata doesn't apply. This is the present suit is filed on the ground is a trespasser, which is a competent. So the decree relied upon by the previous judgment is not binding. It is passed by a court not having jurisdiction. So this evidence you can lead it here. So ultimately the court is permitting directly or indirectly some judgment other. Similarly, insolvency order has been passed, judgment and decree, not by the High Court or District Court. It is passed by Civil Judge Senior Division or a Junior Division who do not have power. A probate has been issued by the Court of Small Causes Court or a Munsif Court who do not have jurisdiction. It should be issued only by the District Court or the High Court, which is not so. So the decree is not binding. So these are the illustrations for the purposes of proving that all judgments which have been obtained are fraudulently obtained. The person defendant was not the tenant, he was not the wife, and insolvent was a bogus crime. He, in fact, he obtained the insolvency order by suppressing material fact. In fact, he has got a factory in Pune, Bombay, Bihar. Sub properties के बाद बहुत सारे हैं. He has suppressed it. I produce here. There is no, by no stretch of imagination, he can be declared as an insolvent. He has fooled the court. He has not produced all the relevant documents. Under the provisions of his the CPC under Order 7, Rule 14, he has suppressed his document. A person suppressing document, he must suffer. All the decree is a nullity. Is not binding, so the judgment cannot be relied upon. That is the Chengal Naidu's case, famous judgment of the Supreme Court. Chengal Varai Naidu, check kare uske andar net ke upar jaake. So the fraud can be set aside at any stage by the court. So for the purpose of section 44, fraud has no limitation also, some judgments say, but under section 17 of the Limitation Act, from the date of discovery of the flat, your limitation is extended. Fraud may have taken place 20 years ago. Your grandfather's signature is forged and properties has been taken in execution. You come to know that this is a forgery has been committed. So you come to know recently, within 3 years from the date of the forgery, you can file a suit. Section 17 of the Limitation Act, from the date of the discovery, within 3 years. So that is how it is, a section 44. So we'll wind up here. Anybody has any question, please ask me. I am winding up today, and tomorrow I don't mind taking a lecture. Tomorrow is Friday. I am available tomorrow. We'll take up 45, 46, 47. Yeah. Till 55 we can take tomorrow. 45 से 55 कल cover कर लूंगा. Anybody has any question today, please ask. Or you are also open to ask question tomorrow. Okay.
Sir?
Yeah.
So,
Fully.
so one clarification to make. So in 43, after a decree is a fact in issue or is relevant under some other provision of act. Sir, is this restricted to the relevancy provisions only or to the entire, applicable to the entire Evidence Act?
In 33, the judgments, previous judgments in 40, 41, 42 are not binding for the purpose of 43. But if the judgment in the subsequent suit and the present suit issues are common, the issues must be common. Please note that. If the issues are common, the judgment can be relied upon. Number one, and when the issues are not common, if the Evidence Act permits the leading of evidence such as like in section 8, motive, preparation, conduct for committing the crime. So A commits the landlord's murder because the landlord obtained a decree for possession against the tenant. Son of a tenant murdering landlord. So the issues may be different, but commission of the crime is on account of him, on account of mens rea. Motive, section 8 permits motive. So there are two separate exceptions. Number one, where issues are same. Issues must be same. The earlier case ke andar 379, the man was convicted. Another second time also is convicted. So the court held that the judgment and decree given by the magistrate in the previous case can be looked into in the present case because the issues were same. Mean charges were same. Issues mean charges. Please note that. If the charges were different, the judgment will not be admitted. But can be admitted provided you are able to show before the court. It is important to take into consideration the previous judgment because that will show the motive, preparation and conduct or any other provisions of the Evidence Act or existence of a right under section 13. There is a custom prevailing in the community. Show that a custom ke liye main dikhana chahta hu. Section 13 of the Evidence Act tells you you can establish a right and custom. So if the present suit is based upon some custom, adoption hua family ke andar of a particular age, at any age, you may show that. So adoption different hai yahan pe, you may show custom. So you should be able to pinpoint under the Evidence Act unless you know Evidence Act mein kaun si requirement hai. So section 8 ke andar ye requirement hai motive, preparation, conduct. The man got up and ran away. That shows his conduct. Isn't it?
Yes, sir. Yes, sir. Understood.
That's
Sir.
how it is.
Got it. Got it, sir. Thank you.
So the two incidents must be present for 33. Number one, the issues must be same, or you pinpoint from the provisions of Evidence Act which section is applicable. So both I given you illustration. Issues are common, then you are permitted to lead evidence. The document will be admitted in evidence. Whether relevant, irrelevant, the court will give a finding. To what extent it is relevant. For the purpose of recording a finding under 136 of the Evidence Act, read with Order 13, Rule 1 and 2 and 3 and 4 of the Code of Civil Procedure. So CPC, you cannot, the Evidence Act, you cannot read in isolation. You should read in conjunction with other provisions of the CPC and CRPC, the procedural laws and substantive laws of the Act. So 33 ke andar jo Act, any other provision of the Act mean that Evidence Act. Evidence Act में which section permits you to introduce the document बताइए आप. Privilege communication बताइए आप. Section 126 के अंदर ये allowed है. I am entitled to bring it. You bring it. The state will take into consideration. This is a privilege communication. This document cannot be disclosed. This is the reason. You may say that here, this is a 30-year-old document. The court can take into consideration. Section 90 बताइए, the court will consider. And you may take up the plea that here I am permitted to bring on record the evidence, namely, for example, I can lead oral evidence of a document which is on record, which is silent. Bataiye, the price is not indicated in the document because under 91, 92, when the document is on record, primary evidence, you are not permitted to lead oral evidence. That is called exclusion of the oral evidence when there is a primary evidence. That is called extrinsic evidence is excluded. But if we tell the court, my lord, in the evidence, in the documentary evidence which is on record, the parties have not agreed what is the exact price. So I am leading oral evidence to show that price must be filled up. Number one. Time is the essence of a contract, nowhere is mentioned, but there was a oral evidence that it was communicated between the parties in the presence of an agent. So I want to examine the agent. That his oral evidence may be permitted. So you have to point out, as a good cross-examiner, you should know the Evidence Act by heart. No, it's like a child's play. And if you don't know the Evidence Act by heart and various judgment, you are not cut out to be a trial court lawyer. Please note that. If you want to be a good trial court lawyer, you should be able to pinpoint. If you are challenging a document between A and B or a third party, the court will ask you, under what provision you are no locus standi. You should be able to leave. It is section 99 of the Evidence Act. I have a right to challenge because my rights are being affected. My property has been included. My property cannot be taken away. I am a third party. I am not a party, but I have filed a separate suit. I made an application under Order 1, Rule 10 to brought on record. Why I am coming on record? Because the law permits me. So you should know this section. If you don't know these sections, the Evidence Act is a section which every lawyer should know by heart. CPC and CRPC and Evidence Act should be able to lay your hand. And illustration को भी जाना जरूरी है. It is not just कि एग्जाम में पास हो गए छोड़ दिया आपने. ये जिंदगी भर आपको हाथी मेरे साथी बोलता आपके साथी बन के रहेंगे ये. Okay, with this we'll conclude and tomorrow we'll take it up. Anybody has any more question, please tell me. Otherwise, reserve your question tomorrow and let me know. Think it over and I am prepared to go back. So from tomorrow we'll take it up the other section 46, 47, 48, 49. Is that fine? Conclude करूं आज का lecture? Is there any more question? Please let me know. I am going to hang up. Waiting to hear from you all. Yes, Mr. Akshay, बताइए. Kumar is come back? Ashutosh आ गए क्या?
Yes, sir. Yes, sir. Yes, sir.
Yeah. Is it okay? Today's lecture will conclude. Okay.
Yes, sir. We can conclude now.
Okay. Tomorrow we'll meet up same 7 o'clock, 7 to 8. Okay. Good night.
Okay, good night.